Welcome to Workshop Owner's Statement of Suspicious Documents. I'm CJ Holmes, founder of Homeowners for Justice, and working really hard to stop fraudulent foreclosures. Before we go any further, I just want to make sure that you understand I'm not an attorney, I'm not a CPA, I'm not a loan modification specialist, I'm not a securitization auditor. I am a licensed real estate broker, and I'm very concerned about the theft of homes from owners. The banks are actually using forged documents, and this is what has led to these workshops. Just please read the legal disclaimer if you will. Please don't hold me liable. I can't be held liable for if these efforts and techniques and strategies will work or not. I don't know your situation. And even if it works for one person in an exact same situation, we can't guarantee it's going to work for someone else because we're all trying and fighting against fraud. Fraud as a business model is extremely lucrative, and right now the banks, their servicers, their foreclosure trust emails, everyone associated in this mess is just out of control and are breaking every law. And you're going to see, because this is today, I'm finally ready to show you at least this beginning basis of the owner's statement of suspicious documents. And please understand, as you may already know, content changes on the website. I update the working documents. We update the information, and we're constantly trying to bring you the very latest and greatest in our effort to stop foreclosures. So to get started, this is a workshop that should follow analyzing the recorded documents. If you haven't watched that workshop, at least the beginning one, and then I also did an update because every time you read these documents you find something else wrong. If you haven't done those workshops, please just put this on pause. Watch those first. They're archived. And then you will understand where we're headed. So I'm assuming that you've already watched those. So you get your recorded documents. And of course, again, as a reminder, that you can only really have these recorded documents once they file notice of default. If you are in limbo land, you've stopped making loan payments, you don't have any notice of default on the property yet, then you're probably not going to have the documents we're discussing, the assignments, the trustee substitutions, and of course we're talking about deed of trust state, not mortgage states. Mortgage states are judicial foreclosures. We're talking about non-judicial states and deeds of trust. So you get the documents, go to the spreadsheet, follow along, analyze, fill out that spreadsheet, and I'm going to show you an example of my latest and greatest filled out spreadsheet with these violations. And I've made it as simple as possible by alphabetizing the violations on the spreadsheet to match the violations on the statement. Because the whole point is to be able to take from your documents, when you don't even really understand what they are in the first place, to actually follow along, gain that understanding, recognize the problems, itemize what those violations are, transfer that information to this statement, which includes the laws. I've quoted the law, so that this then we can send. This is the package that we can send out to all of our local officials. We're thinking district attorneys, supervisors, recorders, sheriff, state officials like the Attorney General's office. Send me a copy, if you will. I will forward, I don't care what state, I will forward that to your state's Attorney General to start a statewide grand jury, hopefully. And then the key is, let's redact some of the personal information. I'm going to recommend that you do that just for your safety and peace of mind. You can, white out your name, but then send copies to every media station. I just have this vision. If thousands of us owners did this, and these statements piled up on these desks without the personal names, so that everyone looking at them would focus on the problems and the suspicious issues in these documents, they would start to really grasp the massive level of fraud and corruption that has been used against the owners in this country. So, first I want to show you where on my Homeowners for Justice library website you can find this information. So as we jump to Homeowners for Justice, you'll see that I've already gotten to the foreclosure defense considerations. That's the first one. If you go to foreclosure defense, the very first foreclosure defense page, this is the page that's going to show up. Scroll down, because right now we're talking about item number 6. Complete an owner's statement of suspicious documents and send to elected officials. Now, I've got here a place where I'm going to link this workshop as soon as we're done, and then I've got the suspicious documents already set up. I will upload our latest and greatest statement for your convenience to use. It'll be a Word document, and then for those of you that for some reason it won't work, I will upload it in a PDF format and you can just retype it. It's a lot of typing, or maybe you could copy and paste it into your Word editor, your Word document type of editor, whatever that might be. So, see, it says right here, this strategy combines the document analysis from strategy number 4. That's analyzing recorded documents. So let's briefly look at a spreadsheet. This is the end result of what it should look like when you're done. Something like this. This is the example that I've included and used in the workshop. What I've done on this sheet and my latest and greatest upload, I have said everything in yellow is defective, because just think about it. We're going to send this information now out to elected officials, attorney generals, prosecutors, and media, and other owners, and they're going to say, whoa, what are you talking about? This is confusing. Let's help them out. So one of the ways to do that is to highlight everything that's wrong. So as you notice over here, I'm scrolling over to focus on, this is now the list of the violations in alpha order, as you're going to see on the statement. So what I did is turn these first 3 black items into a to-do list for owners. What do I have to do? Well, I need to go to the Secretary of State and get notary oath signatures. Do I need to get certified oath signatures from the Secretary of State to file notary complaints? Well, not if the commission has expired. You can't file a complaint. So it goes down the list with those issues. Now, in this particular case, you'll notice all of these numbers. Some things, this particular example did not have any fake power of attorney in fact signatures, which would require a recorded power of attorney. It did not use a defunct lender in any way. I'm going to quickly just scroll down here and show you how we've highlighted the things that are wrong. The fact is, on my website, and also what you can see is Jane Martirana, I happen to have several different signatures for her. It's linked to the suspicious signatures page on my website. So just put in that link. This is your worksheet, but this is also something we're going to copy and include as a printed document in the statement of suspicious documents. But when it's a PDF file like this, these links are actually active. And so you can then print these documents out to include in your statements. It's classic to see these documents printed with all these different signatures. I mean, there is nothing that sways opinion more than to see, for example, just check out Deborah Beard. I just uploaded her. She's a notary. She notarized 4 different signatures of Dominique Johnson, and they're completely different over quite a period of time. And it's that kind of thing that really hits home with everybody. They look at this and they go, wait a minute, that's false notarization. We go, yeah, no kidding. This is how they're stealing the homes, and this is why I'm so upset with it. So you notice that based on all of these items up above, and I will go over them in detail on the statement because they match, but on the statement I have some more clarification plus all the law printed out. Is MERS used? Yep, so we highlighted that in yellow. This is a Bank of America successor by merger to back home loan servicing. It's illegal for any servicer to be the assignee or the beneficiary, so that's illegal. It's illegal. It's an impossibility. This is an impossible beneficiary for U.S. Bank National Association as trustee for CSMC Mortgage Loan Trust 2007-3. It's an illegal. It's an impossible beneficiary. So we've highlighted these. These are all the signatures that we have already linked on our website for multiple different signatures on the same name, notarized by multiple different notaries, by the way. So we've highlighted those. These notaries are now in question because they have notarized robo-signatures. Maybe their signature isn't robo-signature, some are, some aren't. But if they've notarized a robo-signature, it brings their notarization into question. And so as you discover, by the time we highlight everything that we've discovered wrong, then we go down the document list. Is there any document on this house, on this foreclosure, that is not defective? Nope. And that's the point. So now let's look at what I've done on the statement that owners can fill out. I'm just calling it suspicious documents. And here I'm just putting in the name. Now on your real one that you would actually not redact personal information on to send to your district attorney, your supervisor, your recorder, because these are official agencies. They are not going to disseminate this information willy-nilly. But I do recommend that on the copies that you send to media, that you white out your name and the property address if you are concerned about that, particularly if you're still living there. If you've already lost this home to foreclosure, because this works for people that lost homes too, you might not care about that as much. And think about that. Use common sense, please. Please think about it. And the bottom line is those documents with those numbers, it's relatively straightforward for someone to do the detective work backwards to see which property it is. Nevertheless, the date and purchase of the loan securitization, that's the date of your note. That's when you signed. That's when the loan was done. That's what people are thinking. I signed the loan. That's the date of the loan. That's the date that the deed of trust was done. And that's the date that we go back to look at for some of these violations. Then the current master servicer of your note, who is really in charge? One of the mega banks. If you have a sub-servicer or somebody that just bought the servicing, like Aquin or Green Tree, try to look back in your mortgage statements to the very first one. Where'd you get that from? That is going to be your master servicer. And that is the one you're going to continue to hound and hit at. Even if they sold servicing rights, they're still master servicers of that loan. And your foreclosure trustee, we call it a third party because it is a third party being directed by the master servicer to do things. And so in this case, of course, it was Recon Trust. Now you'll see here, this is the MBS, the Mortgage-Backed Security Securitization Trust. And in this case, I'm going to click back here to this worksheet, our spreadsheet. The reason we were able to relatively easily find this information about that pooling and servicing agreement for this is because of this information right here in this cell. They referred to as an impossible beneficiary the U.S. Bank National Association as trustee for, and they named the trust. So if you watch the SEC workshop I did, that was in the second update on analyzing your recorded documents. It's the really simplest form that anyone that has this kind of a reference on their documents can actually go to the secinfo.com website and hunt around and see if you can figure out which one it was in and highlight that pooling and servicing agreement. If so, copy and paste that link right into this document. So back to our statement, you can just copy and paste that document link here. And like I said, as a PDF, when you save this in that format, that link is still active. As a printed sheet, of course, it's not going to be. Now, the blank, the master just says your document, list the type of document, the number, when it was recorded. And so what I've done on this is filled out this. The first document is an assignment, and this information comes right here from the worksheet. You see, it's an assignment, the date it was recorded, and the number. This is the information in these cells that go into the suspicious document list. And so it's an assignment, that number, the date recorded. Here's a corporate assignment, the trustee substitution, notice of default, notice of sale. And in this particular case, we do have exhibits. You may not have an exhibit on some of your documents, and that's okay. If you have an exhibit of some sort, for example, in this case, a notary complaint was filed on this notary because he notarized robo-signatures. So this owner, if that were you, if this were your property, you would have a copy of that complaint under, Exhibit 1, Document 1. And I'm going to just slip down here real quick. If you come down several sheets after the list and after the law, you'll see I've got sample cover sheets. So here's Document Exhibits 1. Here's Document Exhibits 2. So when you print this out for yourself, then you can actually put these cover sheets for the documents and exhibits in front of where you have those documents. It just makes a nice little package. And it keeps everything straight, helps us remember what we're doing, and it really makes it easier for anyone and everyone to find. Just think, office staff in the media stations. They are going to take these packages, and they really are going to soon not care who you are and what property it's on. They're going to start looking at those forged signatures. You mark my words. So here, in this particular case, we're assuming that there was a notary complaint filed and a journal entry and signature samples of Jane Martorano. Now, if you don't have a journal entry, don't say so. Just write in there what you've got. In these particular cases, if you have a journal entry, definitely if you have a journal entry, that's what the notary sends back to you as an original signature of that signer out of their notary journal, if they kept it. Mostly I think it's California. There may be other states that do this. Then you can include that, because that's supposed to be what the signature is. And then it's real obvious if that doesn't match the other signature, it's definitely a forgery on the person that signed. And you got to understand that on these signatures, these forgeries of Lauren Stone, for example, they were notarized. Those notaries actually stated that it was that person, and they had proof and identity that it was them. And so then when you've got all these different notaries notarizing all these different signatures, come on, they've all lied. That is the bottom line. And that's why they're able to get away with this. And it's so lucrative because they make so much money foreclosing. We have to stop them. That's why I'm trying really hard to show them the building blocks of fraud. And this is how we can put it into a format that people will understand. Oh, and I just noticed here on my example, one thing I've ignored and forgot, and I'm going to change, and that is the very first thing I'm going to list is the worksheet. I want you to print the worksheet, even if you can't print it in color, print it, and that is going to be actually item number 1. So in the uploaded new version, the worksheet will be first. Include that, and it should be just one page, but maybe a couple pages, and that's okay. It'll be the exhibit document number 1. And then your actual documents will start with number 2. So as we look at these issues, for example, there's a notary complaint on the trustee substitution, because that's notarized. On notice of default, they're never notarized. It's amazing. But notices of default, notices of sale, and guess what? Rescissions of notice of default are not notarized. They're just signed by somebody. It's just absolutely outrageous and astonishing to me. And while I'm thinking about it, I really want to emphasize here that notices of default never expire. Read my lips, they never expire. So this is what happens, and how these people, these foreclosure mills, are able to foreclose and sell homes years after a loan modification. They don't rescind the notice of default. The owner doesn't know, and so the owner says, I got a loan modification. I'm telling you, I'm speaking to a loan officer yesterday, and his son or brother or relative or somebody had gotten a loan modification. And I said, well, were they in default? Did they have an NOD filed on the property? And he said, yes. And I said, did that get rescinded? And he goes, what do you mean? So I'm telling you, it's not just owners, it's brokers and agents and loan officers. Most people in this country do not understand that as long as that notice of default is sitting there, it can be acted on at any time. It is, according to law, if and when they are going to initiate a notice of sale, they have to give you notice. But it's well documented. Just go to Occupy Bernal in San Francisco, how they take the properties back at auction and never even noticed the owner. Oh, whoops, forgot to send you notice. Too bad. And the owner's going, what? When somebody knocks on the door and says, hey, gee, I just bought this at auction, get out. So when you do, if and when you even consider a loan mod, no matter where you are, if you've made your payments current, if you've paid the loan off, I hear story after story about how they lose the house to foreclosure anyway. And that's because they didn't understand they had to push, they had to insist that that notice of default be rescinded. And it's a piece of paper, it's a recorded document that just says rescission of notice of default and intend to sell, or rescission of default, or rescission of NOD. You know, whatever the title is, it's a rescission. And that means they take it back and no longer does it matter. So you must get that rescinded, otherwise you're a sitting duck. I hear stories all the time that the person paid the entire loan, it was never reconveyed, they never rescinded the notice of default, they foreclosed. And once they file the notice, the notice of sale, the owner, it's 21 days. The owner doesn't even know how to start to fight back. And so many millions of people just roll over and lose the house. So this, word to the wise, if you have an NOD filed, always remember I have an active NOD and it only takes one. They never expire, they never wear out, they're always sitting there. Notices of sale, on the other hand, expire in 365 days. So if you have a notice of sale that's expired, at least even if the notice of default is there, they can't just sell at any time, because until that notice of sale expires, they can sell at any time. Okay, enough about that. So now, as we go down on these items, what you're going to see on this statement are just standard false notarization on such and such documents. I sort of edited this sample to say it's a false notarization of this notary on that document, of this notary on that document, but on each one of the master sheets that you're going to work on, it just automatically says the notary signature does not match oath signature. Notary notarized different signer signatures. So even if the notary signature matches, the notary signature isn't robo-signed, which sometimes they are. If that notary is notarizing different signatures of the same person, they're notarizing robo-signatures, it's got to be false. And so then we've listed out here the false signatures, and basically that's when you have multiple different signatures on the same name on different recorded documents. Now, here's another law, and this is, I believe, everywhere in every state. The assignments giving the power to file foreclosure must be recorded prior to the notice of default. A substitution of trustee does not, and mortgage states don't even have trustees. But in deed of trust states, non-judicial, we have trustees. And unfortunately, it doesn't really matter if that's filed before or after a notice of default or even after a notice of sale. It must be filed prior to the sale. But it can be filed sort of willy-nilly in there. But the assignments giving that authority to foreclose must be filed first. So if it's not, then the notice of default is void. Doesn't mean they don't foreclose. They foreclose this all the time. That's the problem. They have all these frauds and all these suspicious issues and all these illegalities and fake made-up documents that they're taking the houses with. That is the point. And so this is really telling you, which will tell everybody else as you copy this to them. They'll read this and they'll go, really? Now they know too. Now, the servicer is illegally named as an assignee or beneficiary. Absolutely. In this particular case of our example, documents 1, 2, and 3. Let's just take a quick look at that again. What are we talking about? Oh yeah, Bank of America. MERS, in this case, gave it over to Bank of America, successor by merger, to back home loan servicing. They have assigned the power to sell this property to a servicer, and that is completely illegal according to law. We'll look at that in a minute. So here you go. this law actually states, I just pulled a little section out of it, no servicer can be the assignee unless the servicer is or was the owner of the obligation. Sorry, never was. So, and isn't right now. Impossible beneficiary designation. Typically, that's the trustees of the mortgage-backed securities. They can't receive assets from anyone other than depositors. They cannot receive this from banks or servicers, and we're going to look at some of the verbiage on a typical pooling and servicing agreement, which I've included later. Does it have attorney in fact? In this case, it does not, but I've seen entities that are basically, this is the trustee of the mortgage-backed security, the signer is of the trustee by Bank of America, by LSI, loan servicings as attorney in fact. They're just huge convoluted titles, and whenever they use attorney in fact, there must be a recorded power of attorney in the county or with the document. And so I've actually been requesting these powers of attorney from First American Title. Okay, give me this power of attorney to prove that this is true. They can't find them. Linda has already told us that she's only seen one power of attorney correct. So I'm going to say, probably without much exception, most of these attorneys, in fact, statements are just fake. They just say it. They just say it so that they can try to weasel around and come up with some kind of an ownership that, will look legal, work long enough for them to take the house, boom, and then they're gone. And let me remind you again, if you lost your house to foreclosure, I don't really care when, to a mega servicer, and it was a securitized loan, go into the recorder's office, the registrar's office. Go look these up, because the fact is these documents are still there, and you can go find them, and you can print them, and you can do this worksheet, and you can pass this out and say, look, I have an illegal foreclosure. Look at all this fake document that they used, and I didn't know at the time. No wonder it felt wrong. It was wrong. Fake agency designations. Often we see this. For example, Recon Trust as agent for the beneficiary, and the beneficiary is the trustee of the mortgage-backed security. That's like crazy. For example, I think that's what this one says. It's number 4, item number 4. Oh yeah, Recon Trust, NA as agent for the beneficiary, but the beneficiary is the servicer. And so in this case, maybe they have some kind of agent document, some corporate agreement making them, let's make them prove that. And the fact is, the people, you and I, we can't get them to prove that without going to court. But I know that the district attorneys and the attorney general, the prosecutors, they can make them prove that without going to court. So this is a suspicious statement of suspicious documents. This is a suspicious. We think this is fake. We're not claiming it, but it looks pretty fake to me. And so let's itemize it. A missing false beneficiary or forged substitutions. In this particular case, that sort of covers all the things that might make a substitution false, invalid. And so in this particular case, oh yeah, it's the wrong entity. It's some entity that has no right to actually be the entity that's substituting. And the law, as we look at in a minute, actually states that only the beneficiaries, only the owners of the note have this right. And of course, the servicer took that right to themselves. They did this consistently, time after time after time. And of course, virtually every one of the assignments that are assigned and done are done long after the mortgage-backed security trust cutoff date. Remember where the trust cutoff date is? That's when you did the loan. So as we scroll back up here in this case, see, 2006. And so somewhere before the end of 2006, they needed to do all of their pre-assignments. They needed to have those ready and authorized and signed, ready to use in 2006 in case they needed them. And they never did. And so virtually, and if they had, it would have read that way. None of these assignments do. So as soon as you just have your standard typical assignment, it looks very much like the the docs that we looked at, then you know that definitely these were done long after the mortgage-backed security trust cutoff date, so they're all illegal. It's not allowed by the pooling and servicing agreements. In this case, they didn't use a defunct lender. Sometimes they do. On some docs I see that. On most docs I don't. Did MERS show up on any of these documents? Because MERS, there's real legal discrepancy. Bankruptcy court basically around the country is saying MERS has no right. They are not a beneficiary. And I want to put here, and have put here, and am quoting this. MERS claims, they claim to be both an agent, that's the nominee of the lender, and a principal, that's the beneficiary. In like one sentence I'm an agent, the next sentence I'm a beneficiary. And the fact is, they're claiming that in all of our deeds of trust that used MERS, with respect to the same property right. So on the same property, at the same time, they're telling everyone, I'm going to be an agent, I'm going to be the principal. And that's an impossibility. And it simply makes a mockery out of our property laws and records. And I want everyone to understand it. That is the point. I've been saying this. When MERS says I'm a nominee, that's an agent, I'm a rabbit, then the very next sentence they say I'm the beneficiary. That means I'm a tiger. I have all the rights. I can do whatever I want. So how can you be the rabbit and the tiger at the same time? And that's what makes a mockery out of our laws and records. And this is why they call it a smokescreen, an umbrella under which all this fraud has taken place. So then, and of course I point out that in this particular case, well, MERS started it. They started it. Why did MERS start it? Because the original lender was First National Bank of Arizona. So it's just simpler. It's easy. Hey, let's just use MERS. Boom, done. And truly, this is a production mill. They just make these papers up, they just stamp them, and they just move them out and steal the houses. So now I wanted to point out the violation of the OCC cease and desist order of April 13, 2011. All of these were done after that. So it's just simply by record date. Are these documents that have, does any document that has anything yellow on it recorded after 4/13/2011? Yep, all of them. So you just list them. And then the verbiage points out that this directly violates the OCC cease and desist order by robo-signing, forging, or using other deceptive tactics. The same with the U.S. Department of Justice, U.S. District Court issued consent judgments against these banks, again for the very same problems. Obviously, the OCC didn't get much virtually any cooperation. And so the U.S. District Court comes in and says, you got to stop this stuff. And so, again, how to find those, it's pretty simple. You go over here and you look at any one of these recorded dates and which ones were after April 4th, 2012. All of them. So there you go. And your issues are going to be different, but that's how simple it is to transfer the information, once you've got it on the worksheet, onto this onto this statement of suspicious documents. Now, on the notice of default, I wanted to make sure that people understood that all this fraud and all this mess actually makes that notice of default void. It has no power. Now, the fact is, while it's there, and until you get it off, they're going to use it, and they're going to go to auction, and they're going to sell the property. But at least owners can say, look, my notice of default is void, because in this case, it's based on an invalid trustee substitution. The trustee substitutes beneficiaries. And, well, it's the wrong beneficiary, so this trustee substitution is invalid, because this is an invalid beneficiary. So when you start right here from the assignment and then this corporate assignment, oh yeah, and in this case, the invalid servicer made it an impossible beneficiary designation, and then turned right around just a few seconds afterwards and took back the power to make a substitution. So the whole thing is just a joke. It's just fake, fraudulent. It looks legal on the surface. It's completely rife with all of these problems. I mean, B of A, even if the beneficiary was a legal beneficiary, the beneficiary can't give away the beneficial rights and then say, oh, whoops, I want to take those rights back, excuse me, and do something else. This would have had to have been U.S. Bank National Association would have had to have been this one. They signed it over to this one. So the point is, and I want to make it very clear on your documents, and so as you do your suspicious document and your worksheets and you have questions, just email me, because they're fairly quick to answer. Some of them are quick to answer, and some of them I won't be able to answer, and I'll ask for help. But I want to make sure that everyone that gets these documents understands that that notice of default is void, and because the default is void, the sale is void. And then down here I've just got, we certify that, to the best of our knowledge it's true and correct, and sign. And this is the point of the suspicious documents. Now I wanted to go over the laws just real briefly, because I believe it's really important that we always print the law so that people start to look at it and read it. It's only when owners rise up, start working for themselves, thinking on their own, following along, learning this information and spreading this information, will we really get some of the power back in our country that we're missing. So obviously the penal code, every person who knowingly procures or offers a false or forged instrument, and the fact is these are criminal charges that only district attorneys or our attorney general can file. And so we want to make it simple for them. The simpler we make it, the more likely they are to help us out by filing these kinds of criminal charges. And so and again, a declaration recorded, this is a statement, this is a new statement, 292417, A, comes from the Homeowner Bill of Rights, SB 900, and it's a takeoff on the consent judgment. It's almost word for word exactly the same, and that is the servicers are now required, before they can file a notice of default, notice of sale, assignment, or trustee substitution, they have to have accurate, complete, and be supported by competent and reliable evidence. Looks like they're obeying that real well, as you can notice that they are robo-signing, forging signatures, using impossible beneficiaries, and just continuing their deceitful practices. So they violated that, and I want to make sure that everyone starts to see that. Also, they jeopardize all of their licensing laws. If they're a corporation here in the state can go after them and can take away that license. And frankly, I want to see that happen. Here's the third-party encumbrancer. Remember when I talked about it earlier in the show about the foreclosure trustee is a third-party encumbrancer, and under the auspices of the master servicer. So they can't just get away by saying, oh, I didn't know what they were doing. Here's one of the keys. The power to sell. This is the notice of default power. The power of sale may be exercised by the assignee. That's the beneficiary, the assignee. And that's why it's so crucial that we stop the servicers from assigning themselves as the assignee. And I'll show you that law here in a minute. So that is the only person that can do that, entity. And that's why the assignment must be filed before the notice of default. Because if they file the notice of default and then they go, oh, whoops, I better assign it, too late. The notice of default is void. You filed it, the person didn't have the authority to file it. But the people, we need to understand that and catch them in it. Here's the trustee. The substitution of trustee has to be signed by all the beneficiaries under the deed of trust or their successors in interest. And so this is a proper trustee substitution must be filed before that trustee can actually really foreclose. And like I said, This, in California law, can be filed anytime prior to the actual sale. So in your recorded documents, if you're doing them by date, which I strongly urge you, always, no matter what order you get them in, always order them by date so that you can see the date. Now you notice in this particular case, I'm showing again, on the 10th of July, there were 3, so I all recorded. So I recorded them by number. See, it's 1, 2, 3. And that way you know exactly the order, because the order does count. So in this case, let's say that there was a sale, so you'd have a trustee's deed on sale, and then let's say after that there was a trustee substitution that made that sale legal. It's not. Of course, they're going to take the house and they're going to sell it to somebody else, and that's what's called a clouded title. And that's why so many people are going to be really upset when they go to try to sell, because and again, here's another little quick aside. If you know anyone that's in escrow buying a foreclosed property, then I highly urge them, particularly if they are using the bank's escrow company. Bank escrow companies are known, I know for a fact, they did it to me. They lied to the buyer and they deleted a clouded title item off of the title report. We had no way of knowing. So when my buyer went back to sell, First American Title said, hey, the title's clouded, I can't insure this. I can't do your escrow. Now in this case, my buyer, my seller, original buyer turned seller, we went back to the original title company and said, oh yeah, we'll bind it again. Yeah, no kidding. So fraud now gives that title company more business. But what happens if that title company is out of business? Okay, so now you're going to have innocent buyers who have been lied to on clouded title because of issues like this that we're talking about, are not going to be able to get title insurance. They're not going to be able to sell. This is going to hit the fan, in 3 to 5 years when people try to sell. This is another reason I'm pushing so hard to get every owner to really understand how horrible this is and how they've ruined real estate and our property rights and our records and us and our future and our economy. It all goes together. So, now, what I wanted to also point out, here is some case law that I've cited, which actually points out case law that if the entity that sells does not have the right, then that sale is void. So all you guys who lost homes in 08, 9, 10, 11, 12, and you go back and look at your recorded documents and you find this fraud and you find that they did not have the right to sell, that sale is void. How we go back to get those houses back, how you get restitution, I don't know. And I would appreciate your feedback by that, anybody watching. Because this is going to be an issue, you mark my words. If we can get thousands, millions of owners to do this, it's going to be a major issue. Here's some other lawsuits that I've quoted. Here's one, I love this one. Numerous authorities have established that the rule that an instrument, such as a forged instrument, cannot be the foundation of good title. So, hello, when they've done this stuff on all these properties, how can there be good title? There can't. And that's why I believe I've been told, I haven't verified with Old Republic title, that they will not offer title insurance anymore on property that have MERS loans on them. You can see why. Because with MERS they don't have the right to foreclose, and so they forge the documents to foreclose. I've been saying this now for 2 years. So listen up and let's go get our property and our rights back. So as we go down, there's a couple other laws. You can read them. So here's the key. This is the one. This is 15 USC 1641 F1, and then the next one is G1, so that you understand that this is the law that says servicers cannot assign the beneficial rights to themselves. They cannot be an assignee. A servicer of a consumer obligation arising from a consumer credit transaction shall not be treated as an assignee of such obligation for purposes of this section unless the servicer is or was the owner of the obligation. I think I have to fix the typing there. I'll fix that. And so the next section, G1, says, in addition to other disclosures required by this subchapter, 1641, not later than 30 days after the date on which a mortgage loan is so or otherwise transferred or assigned to a third party. We're talking mortgage loans. This is a consumer credit transaction. This law says it is illegal for these servicers to assign the beneficial rights to themselves. Let's go get them. 18 U.S.C. 1341 is mail fraud. They send a lot of this stuff. Half of these things are recorded or sent through the mail. Fraud through the mail. Just a word to the wise. Here's the IRS Bulletin 860 that talks about remix. This is the standard basis on which the IRS whistleblower claim can be filed. And that is that, and also, this substantiates the fact that these mortgage-backed securities needed to have the actual loans and deeds of trust assigned to them legally, which would have been by the close date or within 60 days of the close date of that trust. All those assignments needed to have been done and held in file. They didn't have to be recorded. They had to just be held in file so that they were there. It was authorized. They had them. And then if ever they were needed, they could then be recorded subsequently. They were not. That's how come all these assignments are illegal. And so you can argue, well, an interest in real property is not a qualified mortgage unless the obligation is principally secured by such an interest. And what we're proving to everybody by looking at our documents, just on the face, just what it says on them, that the mortgage-backed securities were not secured. They couldn't have been. Because now they're assigning, years and years later, they're trying to assign them into these mortgage-backed securities, and of course the whole thing is fake. Here's this typical pooling and servicing agreement. The depositor sells, transfers, assigns, delivers, sets over, and otherwise conveys to the trustee. You don't have any bank selling, assigning beneficial rights to some trustee. That's not how it works. And that's why, just as a refresher, I went back into, here's our little worksheet, spreadsheet worksheet. That's why it's so good. The correct mortgage-backed security assignment process is originator to servicer to depositor to trustee. And so in this case, the originator, First National Bank of Arizona, the seller is a DLJ Mortgage Capital Inc., the depositor is Credit Suisse, the trustee was U.S. National Association, the master servicer is listed on the PSA as Wells Fargo. So now we've got B of A doing stuff. This is great. Then you've got other servicers listed, and so then when we actually look at the documents, you see that MERS assigned it to, let's forget everybody else, let's assign it to B of A. A servicer, illegal. So now the servicer tries to assign it back into the U.S. Bank National Association. And so the whole thing is just complete hogwash. It's just complete hogwash. And here it is. The depositor shall report to the related custodian, the certificate insurer, the status of updating all applicable assignments with MERS within 60 days of the closing date. Didn't do it. And shall confirm in writing. That's why they've lost their remix status. They really are not long-term pass-through mortgage-backed securities. That's a whole nother thing. Now, I've included the OCC cease and desist order in April 13, 2011, the key component in it. Within 60 days of the order, so within 60 days of April 13, the bank shall submit to the Deputy Comptroller and the examiner in charge an acceptable compliance program to ensure that the mortgage servicing and foreclosure operations, including loss mitigation and loan modification, comply with all applicable legal requirements, OCC supervisory guidance, and the requirements of this order, and are conducted in a safe and sound manner called the compliance program. The compliance program shall be implemented with 120 days. So that's what, 6 months after April, May, June, July, August, September. So by October, that was to be implemented, and any corrective action timeframe in the compliance program that is in excess of the 120 days must be approved by the examiner in charge. So, as I've said, everything they did after that date is out of compliance. Let's identify it. Let's show everybody how they've been flipping their nose at the OCC, the regulatory agency, and now at the contempt of court, at the consent judgment. So obviously the OCC couldn't rein them in. So about a year later, on April 4, 2012, the United States District Court issued a consent judgment insisting, and all of these judgments, by the way, are linked to that home page. Happens to be, I'm just going to zip right back to the home page here in Homeowners for Justice. Actually, it's the foreclosure defense homepage. It's listed right here, number 1. Always and forever mega bank infraction, file an OCC complaint. Take that to heart. And here are all the links. The 5 consent judgments and the 11 OCC consent orders, so that you can pull the one up for yourself if you like. So back to the consent judgment, every one of these says the same thing, and I quoted them. This is the consent judgment Exhibit A, Item 1, foreclosure and bankruptcy information and documentation. And this is what they wrote in each one of those consent judgments, and those CEOs signed. The CEOs of these entities signed this and said, yes, we'll do this. So read that information. And again, it's basically they are going to, have competent and reliable evidence, and they're going to stop robo-signing and stop using deceitful practices to foreclose. And they didn't. So let's nail them. Now, I believe that's pretty much it. The idea of this, again, is to get the documents, analyze them, follow the workshop, stick those violations on the spreadsheet so that you can easily transfer this information to this statement. Print the statement up. Someone contacted has already done this, printed 8 copies. Then for the district attorney, the recorder's office, the sheriff, and the 5 supervisors of Mendocino County. Now, then, once you've done that, then I recommend you make a copy, redact personal information. If you've got your own documents there, then just white out your name and the property address. People don't need to see that. What they need to see is that you've signed this you've itemized the violations, the fraud, the forgery, the questionable actions, the impossible beneficiaries of the documents that were recorded on your property, and either took the house in fraudulent foreclosure or are going to they're trying to take the house in foreclosure. Please share this with everyone you know. Every owner needs to understand that if they are not yet in foreclosure, it's only a matter of time. And when the facts are these, they have manufactured fake documents to steal over 4 million houses already, and they have another million they're trying to take. What's to keep them from just making up an address? Nothing. They just put anybody's address on there. They can foreclose anybody, whether they own the loan or not. What does it matter? Look at what I'm showing you. It doesn't matter. So the fact is, your neighbor, if I were you, this might be really powerful. Take that redacted copy that you're going to send to the media. Pass it around your block. Make a copy for everyone on your block and give it to them. And with a little, and include, I got an idea, include one of my flyers of foreclosure, and include my letter to the owners. That's found, and just real quickly here, I'll show you where that's found. If you want to do that, what I've done on Activism and Solutions under Share the News, I have actually linked a letter that I've written, open letter to all owners in the country anywhere. And this is the letter, and this is what I say. The foreclosure crisis is far from over. Why are they trying to take homes in foreclosure? Because they make more money. They are ignoring the OCC, the cease and desist orders. They're ignoring the consent judgments. It's not about deadbeat owners. It's all about premeditated theft of middle-class wealth. I tell you, print that, stick it on top of your documents, and print this one too, the flyer I've got for the country. I pulled this information out of the foreclosure map. Tell your neighbors they're next, because these guys are so full of fraud, they're going to end up taking everybody's house. It's just a matter of time, unless we can stop them. So thanks so much for listening. I appreciate it. And please step up, get your documents, figure out what they've done wrong, make these statements. If you have any questions, please ask. I'll do my very best to get answers for you, whether I can answer them or someone else, so that you can help be part of the change that we need in this country. Thanks so much. I'm CJ, signing off.